recording all my videos and stuff. What's going on, y'all? How y'all doing? Welcome to the channel. It's your girl, Phylly, and I'm back. And I'm back with another video. Who we got up here? Miss Lorraine, my friend Miss Lorraine, Mariah. Who else? Did I miss anybody else? Okay. Hey, Teletubby Hips about to get life without parole. Okay. Hello, isn't she lovely? Shalom. How you doing? Miss Jackie Phylly is in the building. How you doing, Miss Jackie Phylly? I talked to Jackie earlier. You know, I talk to Miss Jackie all the time. Yes, I do, child. Oh my goodness. Of course, y'all know we gonna get justice for Carlita. We doing things in order, okay? There will be a trial date. We're gonna be patient, just like Miss Michelle Griggs was. All right. Okay. All right, everybody just speaking. So what I'm gonna do, guys, so you know, Tim and his attorneys, they asked for a full reversal. They wanted an acquittal and a new trial. So they gave their position as to why they should have that. And then the government prosecution has to come back and answer. Then the judge will make a decision. Who knows? I mean, hey. So we're gonna read what we read. We read everything. Remember, we read all those alphabets. Mike Leonard listed every reason why he thought Tim should get a new trial and be acquitted. So now we're going to see what the prosecution has to say. Okay. Yes, ma'am. Glad to hear that. As for me, all is well. Okay, everybody was speaking. Everybody's speaking. Justice for Carlita. Absolutely. Justice for Carlita. All right. Yes, honey. We praying for the family. Hello, everybody. Hello, Z Break. Miss Vicky is in the building. Hey, Miss Vicky. What's going on, y'all? How are y'all doing? Okay. I'm just going to read. It's only 16 pages. This won't be a long live. And then tomorrow we'll go back to reading the testimony. We stopped off. We were getting ready to do the redirect, I think, examination of David Sullivan, the insurance agent. So I paid good money for that transcript, and y'all gonna listen to it. But no, seriously, if you're catching this on the replay, because some of you, not everyone will catch it live, but you know, run it on up into thousands like you guys normally do on the replay. It's all good. I ain't tripping if I ain't got no 4, 5, 6, 7, 800 up in here. Been there, done that. Been there, done that. Okay. Y'all know how it is. Y'all know how we do around here. Mama Jackie, you have to say daughter. Okay. Maybe that's a family member of Jackie's. I don't know. Because we know, rest in peace to Carlita. Hey, Alice, how you doing? Kizzy is in the building. What's up, Kizzy? Let me tell y'all what I cooked. Let me tell you, I got some. That's what I've been doing too. So Tommy loves gizzards, and I love gizzards too. Everybody may not like gizzards, but a fried gizzards, child. I heard Loca talking about ham hocks and everything she was mentioning. I was like, I eat that, Loca. Me and Tommy eat that. We some country folk. But I bought 2 packages of gizzards, washed them up, clean them, cut all the excess stuff off, season them real good, put them in the pressure cooker. And now I'm smothering some in some brown gravy there in the oven, and then I'm gonna fry the others. And I cooked some macaroni and cheese to go with them. Child, we some country folk around here. Okay, I know that's not why y'all here, but I just thought I'd just give y'all that little rundown. Okay, hey Josh, how you doing? All right, guys, we're gonna go ahead and get into it. We're gonna get into it. No, sis Phil, I am making her my mother. Okay. Well, you do that. I love gizzards, child. Me too, honey. You better know it. My grandfather loved them too. Bruce Perry, you are so fun. Thanks for all you do. Okay, Bruce. Well, thank you for stopping by, honey. Hey, Miss Esther, how you doing? Queen, how you doing? Justice for Carlita and Shanquella. You know what? I haven't forgotten about Shanquella. We just have a lot. I love them also, people. Oh, yes, baby. And that pressure cooker got them so nice and tender. Then I'm going to batter them up, some fresh grease. Ooh, child. I'll tell y'all about it. I'm going to take a picture. Me and them gizzards going to strike a pose. All right, let me go ahead and get to this. Hey, Ash, how you doing? There go my other daughter. Hey, Ash. I only eat gizzards and gumbo. Baby, let me tell you something. This is not what I'm gonna do that on the cooking channel, but yes, gizzards got to be in my gumbo. My grandfather taught me that too. You know, I'm from Beaumont, Texas, 45 miles from Lake Charles, 88 miles from H-Town, oh, right outside of Port Arthur. You know, we know how to cook and eat around here. Okay. All right, y'all. Let's go ahead and get started. Okay. So there you have it. It says, yeah, I had to feel like my lashes about to fall off. Y'all know I got these lashes on, okay? Eastern Division. USA, who's the plaintiff versus James Timothy Norman, defendant. It says the United States omnibus response to the defendant's renewed motion. Because, see, he done tried it before. So this is a renewed motion for judgment of acquittal, which was document number 468. Honey, we went over that document because I read every document they ever produced to y'all. Okay, so go back and watch the videos. It says, and motion for new trial, document number 469. This is their response to the defense's request for a judgment of an acquittal and a motion for a new trial. Comes now the United States of America by and through its attorneys, Sailor Fleming, United States Attorney for the Eastern District of Missouri, and Angie Dennis and Gwendolyn Carroll, Assistant United States Attorneys for District, and its omnibus response to defendant's renewed motion for judgment of acquittal. Tim wants to be acquitted, and motion for a new trial states the following. This is their response. All right, introduction. On September the 16th, 2022, following 7 days of evidence and argument, and after approximately 17 hours of deliberations, a jury returned verdicts of guilty against defendant James Timothy, defendant hereinafter defendant, on all counts to include count 1, conspiracy to utilize count 1 was conspiracy to utilize a facility of interstate commerce in the commission of a murder for hire in violation of Title 18, United States Code Section 1958. Count 2, utilizing a facility of interstate commerce in the commission of a murder for hire in violation of Title 18, United States Code Section 2 and 1958. And then count 3. This is everything Tim was convicted of. Count 3. Conspiracy to commit mail and wire fraud in violation of Title 18, U.S. Code 1349. Okay, y'all. Now we finna get into it. We finna see what the prosecution. You know, let me tell you something. When somebody come at you, you got the answer. Let's say somebody strike one of your videos on a copyright. YouTube, if you're in the YouTube, you got the answer. Now, either you're going to make up some stuff and say, oh, they gave me permission. You got to answer that. So this is their answer. Okay. This is the answer. And I believe, let me say this. These prosecutors or the defenses even change in this case. They counter everything and they counter it with respect and they do it much better. They're even changed, to borrow a statement from Mr. Stovall. All right, let's get back to this, honey. Let's get back to reading this. Here we go. It says sections 2 and 1958, conspiracy to commit mail and wire fraud in violation of Title 18, U.S. Code 1349. Defendant now argues, incorporating his previous motion pursuant to Rule 29, that he is entitled to a judgment of acquittal on all counts because the record is absent of evidence beyond a reasonable doubt that defendant intended to Andre Montgomery, that the defendant intended the of Andre Montgomery be committed, claiming that a leap of faith would be required to tie the monetary payments to Terica Ellis and Travell Hill to their respective efforts to have Andre Montgomery Wow, they're trying to say that the money that he gave Terica and the money that he gave Travell wasn't for this. Okay, and the prosecutor's gonna break it down. She got on them red bottom stilettos and she breaking it down. Okay. Defendant's argument rests entirely on the assertion that defendant's testimony rebuts all evidence set forth in the government's case in chief. Okay, and it says page 4 through 5. In relation to count 3, defendant argues that there was no evidence to support the conclusion that defendant participated in a scheme to defraud any of the life insurance companies who received fraudulent applications relative to a policy on Andre Montgomery's life. In addition, defendant also argues that he is entitled to a new trial based on approximately 13 errors in this court's ruling before and during the trial proceedings. For the reasons set forth herein, both motions are without merit and should be denied in their entirety. Now they're getting ready to break it down. Okay. Renewed motion for judgment of acquittal. Legal standard. Under Rule 29, this court, on defendant's motion, must enter a judgment of acquittal on any offense for which the evidence is insufficient to sustain a conviction. And then they break down and they're going to always give you a case that you can refer back to, honey, and say, this is how they did it on this case. Okay. So this was United States versus Stacks. All right. In 2016 in the 8th Circuit. A district court must consider a motion for judgment of acquittal with very limited latitude and must neither assess witnesses, credibility, nor weigh evidence. All right. Quoting from the U.S. versus Johnson. All right. 8th Circuit, 2007. Now, this is the prosecution giving reasons and showing you things from the past of why the defendant's case is without merit. Okay. A guilty verdict is overturned only if, viewing the evidence most favorably to the prosecution, no rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. We're going to cite another case, U.S. versus Sanchez. All right, 8th District, 2015. And then U.S. versus Lewis, 8th Circuit, 2020. Look them up if you want to. U.S. versus Bradshaw, 8th Circuit, 2020. The 8th Circuit, not the 9th or the 10th, but the 8th Circuit, views the evidence in the light most favorable to the guilty verdict and grants all reasonable references that are supported by the evidence. They did their homework, okay? Now they're going to cite U.S. versus Dean, 8th Circuit, 2015. If evidence consistent with guilt exists, we would not reverse simply because the facts and the circumstances may also be consistent with some innocent explanation. Even where the evidence rationally supports two conflicting hypotheses, the reviewing court will not disturb the conviction. Come on, somebody. United States versus Griffith. All right. United States versus Huck or Hayek. 8th Circuit 2017, and then that was 8th Circuit 2015. That's where that last statement came from, where they ruled in that when they says even where the evidence rationally supports two conflicting hypotheses, the reviewing court will not disturb the conviction. And they based that on previous cases, U.S. versus Griffith in 2015 and U.S. versus Hayek in 2017. Okay, so they giving you something that you can, what they doing, they giving you their receipts. Okay, they popping the defense and a lie, and they giving you receipts. All right, that's what they doing. Okay, let's keep reading, honey, because we got to get through all 16 pages. Number 2, the court properly denied defendant's motion for judgment of acquittal on all counts because the evidence was sufficient to sustain convictions. Evidence presented at trial was not only sufficient to sustain the convictions on all 3 counts of the superseding indictment, but it was overwhelming. I wasn't in the courtroom, but we finding out everything right now, okay? There is no basis to grant a judgment of acquittal on any count, and this court should reject defendant's arguments. What follows will provide a brief outline, not all inclusive, of the government's evidence at trial. To establish that defendant actively participated in a plot to use a cellular telephone to have his nephew, Andre Montgomery, hereinafter they're going to refer as Montgomery M., the government first presented defendant's own text messages with co-defendants Y.L. Yogman, exhibit number 20 and 2P, Travell Hill, exhibit 2J, 2N, and 2S, and Terica Ellis, exhibits 2H and 29. And then they put that little 1 there, and I'm going to read what that says in a minute. As well as the unindicted co-conspirators, Chris Carroll, Big Chris, White Boy, okay, exhibit 2F, and Ed Chandler, exhibit 2E. Now, this little 1 down here says exhibit 29 contained Facebook instant messages that defendant and Terica Ellis had exchanged on the day of Montgomery's M. All right. That's what that little 1 up here, see where it says exhibits 2H and 29, then it has that little 1 up there. You come down here, and this is the explanation for that 1. All right. We just want to make sure that we all understand what's going on here, honey. What y'all talking about over here? Okay. Let's say, all right, now, okay. We're going to keep on reading. And feel free to support the channel, honey. This reading it can be tiresome. So you can super chat or you can cash out me. All right. Okay. These documents are not free, All right, here we go. Okay. It says the government also introduced certified cellular telephone records for most, if not all, of the users to establish that they were the subscribers of the respective phone numbers. Those phone records also work to establish the location data for the cellular telephones for March 13th, 14th, and 15th of 2016, which served to corroborate the testimony of government witness Terica Ellis, Travell Hill, and Daryl Howard. Now you see there's a 2 up there by Daryl Howard's name. So there's going to be a little footnote that we're going to read here in a minute. It says this location information was summarized by government expert witness, Special Agent Bastain Fraud. Remember, we went over stuff that he said already. With the assistance of Demonstrative Exhibit 16. Oh, I got a cash app. Thank you, Miss Lorraine. I sure do appreciate you. Thank you so very much. It says, this information was summarized by government expert witness. Hold on, guys. Look. I don't want to have to do this. I mean, well, I do want to do this because I thank y'all for my support. Thank you. Thank you. Okay, let's get on back to reading, honey. Oh, Miss Vicky, thank you, Miss Vicky. Thank you so much for my super sticker, honey. Okay. Thank you. Time to breathe in between all this reading, shoot, child. Let me take a sip real quick, because baby, Honey. Okay, here we go. Where was I? So it says that this location, remember I said that that 2 right there by Daryl Howard, there's going to be a footnote. So it says this location information was summarized by government expert with witness. Oh, I got me another cash app. Oh, honey, thank you. I guess if you ask, if you know a closed mouth won't get fed, ask and ye shall receive. Thank you, Jerry Lynn. Thank you so very much, honey. I want thank you. Okay, I'm gonna keep reading now. I'm not gonna keep doing that. Okay, here we go. But thank you guys for whatever you do. All right. It says this location information was summarized by government expert witness FBI Special Agent Bastain Fraud with the assistance of demonstrative exhibit 16. Oh my goodness, I got another cash app. Ooh, Ellen, thank you. Ooh, I got to say this one, honey. Thank you to everybody. Thank you. I'm not gonna stop no more, guys. Okay. Because people be leaving me messages saying, oh, honey, you reading too much. The intro is too long. But you know what? I bought these documents. Let me read them how I want to read them. Okay. But no, thank you for your support. The government also introduced text messages between Montgomery and Terica Ellis in the days leading up to his M, as well as the day of his M itself. Exhibits 4D, 4E, and 4I. Honey, we read all those text messages. Remember one Saturday morning, we had all the text messages from everybody and their mama. Okay. Importantly, the cellular telephone data established that defendant and Ellis procured burner cell. That means they got them. Burner cellular telephones, which were used only on the day of Montgomery's M. Okay. Think about that. They only use the phones on that day, y'all. All right. It says Ellis testified that the defendant, which is Tim, instructed her to find Montgomery's location, and we will be reading her testimony. So you guys just hang tight. Ellis testified that the defendant instructed her to find Montgomery's location throughout the day. Then relay that information back to him. She further testified that they use only those devices to communicate with each other throughout the day. The location data of defendant's burner cellular telephone followed the location data for defendant's two legitimate cellular devices, which were subscribed to him as testified by FBI SA Fraud. So they're letting you know that his regular phones that he had with him, they could still be pinged. You remember we had that guy, I called him Vegas. He broke that all down to us. He broke that down to us long before we even got this testimony from the special agent. Okay. It says Ellis testified and her cellular data was confirmed that she was at the scene of the M and contacted Travell Hill to advise she was present. Hill told her to move, at which point she began driving away. Then she heard gunshots. Hill testified that he asked Montgomery multiple times outside the residence at 3964 Natural Bridge. The call to the FBI, the call to 911 for the shooting went out at 8:02 p.m. as demonstrated in the government's exhibits 53B and 53C. And remember I told y'all, here's that footnote. Number 2, that was by Daryl Howard's name. It says that to establish the location information for Daryl Howard, the government introduced Exhibit 27A, the subscriber and location information associated with his Google Mail and djbeats27@gmail.com. Now listen, everybody that's got all these little emails and stuff, baby, they tracking us every time we send something out. They watching us. Just know that. Okay. It says at 8:03 p.m., Ellis testified her cellular data confirmed. Ellis testified and her cellular data confirmed that she called defendant, at which time, that's Tim, advised her to leave the area and dispose of her cellular telephone. At 8:06 p.m., Daryl Howard testified that he received a call from the defendant, Tim, who advised him to pick up a bag that he had forgotten at the Chase Park Plaza. The call was verified through defendant's cellular telephone records in Exhibit 6, page 171. So as soon as Tim realized it was done, he called him at 8:06. Terica called, let's go back up here, at 8:02, she called Tim. 8:03, her data confirmed that she did. And it says at 8:06 p.m., Howard testified that he received a call from the defendant who advised him to pick up a bag that he had forgotten at the Chase Park Plaza. This call was verified through the defendant's cellular telephone records in Exhibit 6, page 171. Howard testified that he returned to the Chase Park Plaza to quickly pick up the bag, which was confirmed through the location data of his DJ Beats 27 Gmail location data admitted as government's Exhibit 27. So they already admitted that. On March 16th of 2016, 2 days after Montgomery's Travell Hill testified that the defendant told him to meet DJ or either Darrell Howard to accept $5,000 in cash. Defendant is Tim, okay? So Tim told Travell to meet DJ Howard. Remember we had a lady call in that say she knew the DJ? Remember that, y'all? It says Hill testified that he believed that this payment was for the completion of Montgomery's demise. Howard testified that he drove to the Peabody housing complex and photographed the bundle of money that he was ordered by the defendant, aka Tim, to deliver to Loco or Travell Hill. Remember when we found out that that was his nickname? Remember the lady that been knowing him since he was a little kid say his name on the streets was Loco? We broke all of that news first over here, honey. Okay. It says that photograph, Exhibit 27B, was saved to his DJ Beats 27 Google account with metadata establishing that the photograph was taken on March 16th. That's the photograph of the money. At 3:03 p.m. Darrell Howard, boy, they know everything. They know whatever picture you, they know everything. It says Darrell Howard's Google location data then placed him in the Peabody housing complex approximately 20 minutes later, from 3:19 p.m. until 3:22 p.m. He wasn't there long. He was only there about 3 minutes. Okay, let me see what y'all saying over here. What is going on? What y'all talking about over here? You are welcome, Miss Jackie. Thank you. Okay. Google will get you. Yeah, Google watching everything. Hey, Maria, how you doing? How does he think getting out of this? Stevie Wonder can see that there's evidence. Okay. They say, come on, somebody. Okay, Google. All right, let's get back to reading. It says, in order to establish defendant and co-defendants Y.L. Yogman's conspiracy to commit wire and mail fraud in support of count 3, the government presented evidence of the submission of 5 different life insurance policy applications insuring the life of Andre Montgomery, on which defendant was the 100% beneficiary. Then it says the government also submitted defendant's own text messages with Yogman Exhibit 20, in which the defendant and Yogman described not discussing the policies in front of Montgomery, hiding the policies from Montgomery's mother, and in which Yogman instructs defendant to impersonate Montgomery on the phone with at least one of the life insurance companies, to which defendant agrees. The 5 policies all contain false and inconsistent information with regard to Montgomery's health, income, employment status, and home address, and were completed utilizing telephone calls, faxi smiles, which is faxes, and electronic mail communications with the various companies. Child, they did a whole lot, honey. Hey, Loca, how you doing? Loca Libra is in the building. Okay, y'all, let me finish now, honey. It says, to rebut the government's evidence, defendant testified that Yogman alone was responsible for the information contained in the policies and that there never existed a scheme to defraud any insurance company or to M. Montgomery. Yeah, right. A jury's credibility determinations are virtually unreviewable on appeal. Come on, somebody. Now, they're citing something from another case. It says this is from the U.S. versus Jefferson, 8th Circuit, 2011. It says a jury's credibility determinations are virtually unreviewable on appeal, meaning on appeal, you can't go back and review what the jury already decided, okay? It says then, thank you, Miss Lorraine, for another cash app. Thank you so much. I do appreciate it. Yes, I do. You know I do. Oh, and I got a super sticker. Thank you, Josh, for the $10 super sticker. Yes, this reading can be draining. Thank you. Thank you. Okay, I'm gonna get back to it because this is getting interesting. Okay. It says the jury clearly did not find defendant's testimony to be truthful or compelling in the face of the overwhelmingly corroborated testimony of the government's witnesses. Furthermore, on September the 12th, 2022, this court made a finding pursuant to the U.S. versus Bell, a conspiracy existed, that defendant was a member of the conspiracy, talking about Tim, document 370, page 3. It says the court further ruled that the overwhelmingly preponderance of the evidence has shown that defendant James Timothy Norman, defendant Wael Ribby Yogman, Terica Tanisha Ellis, Travell Anthony Hill, Ed Chandler, and big boy, white boy Chris Carroll were engaged in the conspiracies charged in counts 1 and 3 of the superseding indictment. It says there was more than sufficient evidence to support each count of conviction. As such, defendants' renewed Rule 29 motion, document numbers 468, should be denied. Okay. All right, here we go. Woo. B, defendant's motion for a new trial, document 469. Defendant raises several claims for which he believes he is entitled to a new trial pursuant to federal crime page 33. The majority of these issues were briefed prior to or during trial, in which case the government has referred to its previous briefing herein. Below, the government addresses defendant's arguments in the following order. The magistrate's court denial of defendant's motion to suppress and this court's subsequent adoption of those findings. The admission at trial of text messages between Andre Montgomery, the admission and the testimony of co-defendant Travell Hill, the admission of text messages between defendant and his civil attorney regarding the collection of life insurance proceeds, the admission of the testimony of government expert Bastain Fraud, the denial of various motions to continue based on alleged Brady, Giglio, and Jinx violations, the denial of defendant's motion to dismiss based on co-defendants Travell Hill's drug use. This is all the things they listed. The denial of defendant's motion to compel the production of early Jinx material. The denial of defendant's motion to compel testimony of Wiley, Christopher Carroll. Alleged objections of the proffered jury instructions. Defendant's objection to this court's response to jury notes. Ooh, they had a lot. Defendant's various motions for mistrial during trial. This court's granting of government's motion to exclude the testimony of defendant's proposed expert, Russell Luce. The court's ruling on all evidentiary objections and defendant's untimely objection to alleged statements made during government's closing arguments. All right, legal standard. Whew. Let me see. Let me just take a 2-minute break, y'all. Boy. Let me tell y'all something. This reading, baby. Okay. Thank you for the super sticker, Miss Louise. I do appreciate it. Thank you so much. And then there's Josh. Thank you so much, guys. I appreciate that. I had to take me a look. Take a 2-minute break from reading because, baby. Oh, okay. Let's get back to it. Legal standard. Pursuant to Federal Rule of Criminal Procedures, upon defendant's motion, the court may vacate any judgment and grant a new trial if the interest of justice so requires. However, district court must exercise the Rule 33 authority sparingly and with caution. U.S. versus Campus, 8th Circuit, 2002. They're letting you know where you can go to see why they're saying this. It's already been let's say, I won't say voted on. It's already been, a judge has already ruled upon something regarding this. That's the word I'm looking for, ruled upon. Then it says, quoting United States versus Lincoln. Who, Abe Lincoln? 8th Circuit, 1980. Unless the district court ultimately determines that a miscarriage of justice. Come on, y'all. Where have we heard that? A miscarriage of justice will occur. The jury's verdict must be allowed to stand. Now, do we think a miscarriage of justice was held here in Dre's in this case? Okay, I don't think so. It says, so without a miscarriage of justice, the jury's verdict, it must be allowed to stand. Okay, if it fit, if it don't fit, you can't acquit. Let me say it like that. The remedy is reversed for exceptional cases in which the evidence preponderates heavily against the verdict. U.S. versus Knight, 8th Circuit 2014, and U.S. versus Stacks, 8th Circuit 2016. Then it goes on to say, A, the trial court properly adopted the report and recommendation of the magistrate court regarding defendant's seized cellular telephone. You know, Tim made a big deal about the telephones. He said that they seized them improperly. So let's see what the United States, what the prosecution is going to say about this. Okay, here we go. On December 23rd, 2021, prior counsel of defendant Joseph Hogan, you know, he's had several attorneys, filed a motion to suppress evidence extracted from a cellular device found in defendant's pocket. It wasn't on the table, it was in his pocket at the time of his arrest on the instant charges, document number 183. The government responded, and on March 25th, 2022, United States Magistrate Judge Nanette Baker, remember Nanette, held an evidentiary hearing during which the government called FBI Special Agent Christopher Faber. S.A. Faber testified that when defendant was searched pursuant to his arrest, a cellular telephone, later admitted both at the hearing and at the trial as Exhibit 1, was located in his pocket of the defendant's shorts. S.A. Faber also testified as to 2 recorded jail calls admitted during the hearing the defendant made on August 24th, 2020, following his arrest, during which defendant stated the following: "They bang on the door. I open it. There's 7 mother freakers with machine guns pointed in my face. They take me in, man. I ain't got nothing but my gym shorts, my effing phone, and a tank top." So your phone was not on the table, Tim. You said right here that you had your phone. Then it says, in another recorded call on August the 24th of 2020 to an unidentified female, defendant stated the following, beginning at the 2-minute and 30-second timestamp. Timestamps can be important, especially when you're fighting counter strikes on YouTube. Okay. It says, "I ain't even had enough time to effing turn my phone on live or record. None of this shit. Just hands up. So they just took me. I had on my gym shorts, my effing tank top, and my phone and my flip-flops. They effing just took me." Come on, somebody. Now, did he just admit that he had his phone? Or is it me? Let me see what y'all saying. Did he admit that he had his phone? Looks like he admitted it to me. Okay. All right. It says, despite these statements, defendant testified at the evidentiary hearing that Exhibit 1 belonged to him, but that FBI agents had retrieved the cellular telephone from inside his home and not from his person. His person means upon his possession, his body. Okay. S.A. Faber subsequently secured a federal search warrant for the device, the contents of which were largely included during the government's case in chief. On April 15, 2022, Magistrate Judge Baker entered her report and recommendation that defendant's motion to suppress be denied, stating she found Agent Faber's testimony to be credible. Without objection from defendant, hold on, y'all. Wait 1 second. Okay. It says Agent Faber's testimony to be credible. Without objection from defendant on May 24th, 2022, this court entered an order adopting the report and recommendation of the magistrate court and denying defendant's motion to suppress. Woo, honey, y'all might have to play this back a couple of times to get the full understanding because it is a lot. Woo. Ordinarily, when reviewing a district court's denial of a suppression motion, the Court of Appeals reviews the court's factual findings for clear error and whether the Fourth Amendment was violated. De novo. United States versus Rodriguez. All right, 8th Circuit 2007, citing United States versus Bell, 8th Circuit 2007. However, in defendant's case, much like United States versus Bell, however, in defendant's case, much like Rodriguez, defendant failed to file objections to the report and recommendations, thus waiving his right to de novo review by the district court of any portion of the report and recommendations of the magistrate judge, as well as his right to appeal from the findings of fact contained there. Whoo, this stuff is technical, honey. U.S. versus Newton, 8th Circuit 2001, Griffini versus Mitchell, 8th Circuit 1994, honey. They're going all the way back to the 90s. As defendant has waived his right to contest the findings of the magistrate judge report and recommendation and this court's subsequent adoption of it, defendant's motion should be denied on this point. However, even if the court were to address the merits of his belated challenge to the magistrate court's findings, his claim still fails. Defendant's argument rests solely on the credibility of defendant's testimony at the suppression hearing, which conflicted directly with the statements he made in recorded jail conversations, which the government introduced as evidence to multiple people in the days after his arrest about where his cellular telephone was located at the time of his arrest. See, he was calling around, running his mouth. He had diarrhea of the mouth, saying that his phone was in his pocket, okay? It says a credibility finding made by magistrate judge after a hearing on the merits of a motion to suppress is virtually unassailable on appeal. Look that up if you don't know what it means, okay? U.S. versus Schaefer, they're quoting that, 8th Circuit 2010, quoting United States versus Starr, 8th Circuit 2008. The decision to credit a witness's testimony over that of another can almost never be a clear error unless there is hold up, y'all. Let me get it right. Extrinsic evidence that contradicts the witness's story. Whew. Child, these words. Okay, there's extrinsic evidence that contradicts the witness's story, or so you get tired tongue after reading so long, or the story is so internally inconsistent or implausible on its face that a reasonable fact finder would not credit it. Oh my goodness, child. United States versus Harper, quoting U.S. versus Heath. And somebody just told me, you're getting much better at reading these documents, baby. But every now and then I run up on a word that just takes it out of me. Okay. The testimony of S.A. Faber, Special Agent Chris Faber, was not refuted by, and here they go again, extrinsic evidence, by any extrinsic evidence. To the contrary, defendant's own recorded statements undermined the credibility of his testimony at the suppression hearing. As such, defendant's motion should be denied to this point. Now, this was their response to the defense saying, hey, they got the phone illegally. So that's what I just read. That's their response. And you guys can run this back and play it. If you're watching this on the replay, thank you so much. All right. The trial court properly admitted text messages from Andre Montgomery for his plan to stay away from St. Louis. As set forth in the government's pretrial brief, the government admitted Exhibit 4G at trial, which consisted of several communications between Andre Montgomery. Prior to his admission, the court limited one of the government's proposed portions of Exhibit 4G so that it would not reference what Tim, defendant, was capable of, as it implied past bad acts on behalf of the defendant. The court properly considered the totality of this exhibit. I got that right. Considered the totality of his exhibit and the government's arguments that it was seeking admission of 4G, not for the truth of the matter asserted, but to establish Montgomery's state of mind, his plan, intent, and motive pursuant. The government reasserts all arguments set forth in its pretrial brief by reference and asserts that defendant's motion should be denied on this point. Ms. Lorraine, you say I got this? Woo, honey. You know what? I need to go cut this oven off. So let me take a 60-second break, go cut this oven off. I'll be right after these messages. I'll be right back. I'm back. Okay, here we go. Where we at? All right, we're going to C. The trial court properly permitted testimony from Travell Hill about his conversation with defendant on March 14, 2016. The court properly admitted the testimony of Travell Hill pursuant to the 8th Circuit precedent as set forth in government's motion response, document number 299, okay? The government hereby incorporates that response by reference, and defendant's motion should be denied as to this point. That was C. Then it goes on to D. The trial court properly admitted communications between defendant and his Texas-based civil counsel regarding attempts to collect a life insurance policy, Exhibit 2Q. And they say the court properly admitted Exhibit 2Q and incorporates by reference all arguments set forth in its motion in limine response in document 295. Defendant's motion should be denied as to this point. All right, they're just answering everything that the defense put out there, saying why Tim should get a new trial or should be found just not guilty. Okay. Yes, thank you, Miss Jackie. Yes, tell them to hit that like button. You better come on and moderate, Miss Jackie. You better follow Kizzy and Miss Vicky. Moderate. Okay. The trial court properly permitted the testimony of FBI Special Agent Bastain Fraud regarding cellular location information. It says this court properly admitted the expert testimony of FBI Special Agent Bastain Fraud and incorporates by reference all of its previous arguments set forth in document number 300. Defendant's motion should be denied as to this point. Here's another one they're answering. The trial court properly denied defendants' various motions to continue based on Brady, Giglio, and Jinks Act, document 338. The court properly considered at least 2 separate motions by defendant to continue the trial date and relies upon arguments made before this court and set forth in its respective responses, incorporated herein by reference. Defendant's motion should be denied as to this point. G. The trial court properly denied defendant's motion to dismiss indictment and motion to bar Travail Hill's testimony based on extensive drug use. Now, this is why they're saying that the court did the right thing. They says this court properly denied defendant's motion to dismiss the indictment or, in the alternative, to bar the testimony of Travail Hill based on his extensive drug use. The government reincorporates all arguments set forth in its response, document 309, and asserts defendant's motion should be denied on this point. The trial court properly denied premature motions to compel Jinks Act materials, document 231 and 232. And this is why. It says the court properly denied defendant's motion to compel the production of early Jinks material. The government reincorporates all arguments set forth in its response and asserts that defendant's motion should be denied as to this point. Here we go. The trial court properly denied defendant's motion to compel co-defendant Wally to testify at trial, and also properly denied defendant's motion to compel testimony on Christopher Carroll. So they're telling the court that they did the right thing by not forcing Wally and Chris to testify based on the defendant saying Tim wanted them to testify, okay? Tim wanted them to come in there, sit in that witness stand and snitch while he looked them dead in the eyes and look at big Chris Carroll. After all we done been through, this is how you gonna do me. Everybody ain't your friend. It says on August 20th, 2020, co-defendant Wally Yogman was charged with 1 count of conspiracy to commit mail and wire fraud and 5 separate counts of aggravated identity theft. On July 22nd, 2022, Yogman pled guilty to the sole count of conspiracy to commit mail and wire fraud. The plea agreement Yogman entered into stated that he and the defendant conspired to submit and collect upon fraudulent life insurance policies. Yogman's sentencing was then scheduled for October the 26th, 2022, approximately 1.5 months after the completion of the trial in this matter. During the course of the trial, counsel for defendant indicated they were attempting to serve Yogman with a subpoena to testify on defendant's behalf. But let me tell you something, baby. When somebody know that they trying to get served, they will hide and run. They'll know that it's out there and they'll hide. Okay, they'll hide from and brag about it. Okay, after 2 unsuccessful attempts, the government contacted Yogman's attorney, Neil Bruntrager, who indicated to this court that if called to testify at trial, Yogman would assert his Fifth Amendment rights and refuse to answer any questions. I plead the Fifth. That's when you know you're guilty. You only plead the Fifth when you're guilty. Come on, somebody. Chris Carroll was never charged in the in-for-hire conspiracy for which defendant was tried. However, this court did make a finding pursuant to the U.S. versus Bell that said conspiracy did exist, and that for purposes of the admission of Chris Carroll's text messages, Mr. Carroll was a member of the conspiracy and his statements were in furtherance thereof. Chris Carroll is currently and was at the time of trial charged in a separate conspiracy to commit bank fraud and money laundering under case number. And we can pull that case and we're going to see how it ended up. Okay. I might pull that tomorrow. Carroll was represented by his attorney, James Martin. During the course of defendant's trial, counsel for the defense successfully served Carroll with the subpoena to testify. Carroll was brought before this court with his attorney in order for the defense counsel to conduct an offer of proof, during which time Carroll, upon the advice of his counsel, repeatedly invoked his Fifth Amendment rights against self-incrimination. The appellate court reviews for abuse of discretion the decision not to compel testimony after a witness invokes his Fifth Amendment. After they invoke the Fifth, you really can't compel them to testify, is what they're saying. Fifth Amendment right against self-incrimination. And they say you can go and look at U.S. versus Blaylock, all right, 8th Circuit 2005, and U.S. versus Washington, 8th Circuit 2003. The district court is to review the potential testimony. The district court is to review the potential testimony outside the hearing of the jury and order the witness to answer only if it's perfectly clear that the answer cannot possibly tend to incriminate the witness. United States versus Campbell, 8th Circuit 2005, citing Washington, and then another one. It says representation by the witness's counsel that the witness will invoke his Fifth Amendment rights is sufficient for the district court to refuse to compel that witness to appear. So they're saying that if they say I'm going to plead the Fifth, you don't need to compel them to appear, although Tim wanted them to appear. Then it says you can go to U.S. versus Warfield, 8th Circuit, 1996. We back in the 90s. Defendant cites no law or authority under which this court could have compelled the potentially incriminating testimony of either Wally or Chris Carroll. As such, defendant's motion should be denied as to these points. Woo! Here's another one. J. As the jury instructions in this matter were agreed upon, the trial court properly instructed the jury. It says, Federal Criminal Pages 330 sets forth that failure to object in accordance with this rule to the giving of jury instructions precludes appellate review, except as permitted under Rule 52B. A party generally may not assign error to a jury instruction if he fails to object before the jury retires or to state distinctly the matter to which the party objects and the grounds of the objection. Okay, following an informal instruction conference, the parties were able to agree on all the instructions submitted to the jury. They didn't object at that time. It says no objections were lodged during the formal instruction conference on prior to the jury retiring to commence their deliberations. If they were going to object, they should have done it before they went to deliberate. It says, as defendant waived any objections to the tendered jury instructions, defendant motions should be denied to this point because they didn't object to anything during that time. Okay. The trial court properly instructed the jury with respect to all jury notes. This court properly considered and responded to all jury notes submitted during the course of their deliberations in this case. The court relies upon the record made at the time these notes were submitted and the respective responses given by this court. Defendant's motion should be denied to this point. Whew. L. The court properly denied all motions for the mistrial. It says the court properly considered and denied all of the defendant's motions for mistrial during the course of the trial on this matter. The government relies upon the record made at the time these motions were made and asserts defendant's motion should be denied on this point. M. Oh my goodness, we're going through every alphabet, aren't we? The trial court properly excluded proposed defense expert Russell Luce. So They wouldn't let that witness testify, which was a defense witness. So this is why they're saying that the court did the right thing. They said the government reincorporates by reference all arguments set forth in its motion to exclude document 327 and asserts that having improperly considered and excluded the testimony of proposed expert Russell Luce, defendant's motion should be denied on this point. The trial court properly considered and ruled on all evidentiary objections. Assuming a timely objection, an appellate court will reverse evidentiary rulings only if the district court abused its discretion in admitting the evidence or testimony. And they say we're citing U.S. versus Shedlock, 8th Circuit, 1995. U.S. versus Lil Amos, 8th Circuit, 1985. 1985. My. If the admission of let me tell you something. Once a case has been tried and it's on the record, baby, it can be used throughout the test of time. It says, if the admission of a contested piece of evidence was not timely objected to at trial, let me do this again. If the admission of a contested piece of evidence was not timely, Keisha say, take a drink of water. If the admission of a contested piece of evidence was not timely objected to at trial, an appellate court will review for plain error. U.S. versus White Bull, 8th Circuit, 2011. So it says the court properly considered and ruled upon all evidentiary objections prior to and during the course of the trial on this matter. To the extent a timely objection was made, the government relies upon the record developed during the course of the trial. Defendant's motion should be denied on this point. Somebody said that's the year of my car. That's a good year. Okay, now we're on. The government made no improper argument during closing, nor was any argument objected to during trial. So they're saying they didn't do anything wrong and the defense didn't object. So let's see what they say. It says, counsel for defendant misstates the content of the government's closing argument. I got to get the closing argument. I want to read those. It says the government argued during closing that as to count 3, the issue was not whether Andre had actually signed the insurance application, but rather whether defendant conspired with co-defendant Wally to knowingly deceive the insurance companies to obtain and collect on a life insurance policy. The government then proceeded to point out, among other items, the text messages between defendant and his co-conspirator and corresponding insurance records, which established defendant's guilt. No part of his argument was improper or inconsistent with evidence that had been admitted during the course of the trial. In the absence of a timely objection, it is appropriate to review for plain error whether a prosecutor's improper statements during closing argument warrant a new trial. And you can go and look at U.S. versus Young, 1985, or U.S. versus Davis, Circuit Court, 2008. It says this legal principle presumes that any improper statement or argument was made at all. Given that no improper arguments were posed, they didn't say anything at the time, and no objection was made, defendant's motion should be denied on this point. Wherefore, the government requests this honorable court enter an order denying the defendant's renewed motion for judgment of acquittal, document 468, and motion for new trial, document 469, respectfully submitted by Sailor Fleming and Miss Angie Dennis and Gwendolyn Carroll. Okay? Woo! Child, now we got to wait on the judge to make a decision. And with that being said, I done read all 16 pages. Now, your girl is tired, and I got to get ready to go to bed so I can go to work tomorrow. All right, y'all. Thank y'all so much for hanging in here with me. Again, if you're catching this on the replay, please make sure you hit the like button, leave a comment, get us in that algorithm. Okay, make sure you all have hit that like button, leave some comments. It helps us out. All right. Thank you all so much. Thank you to everybody that stopped by. Thank you, Local, for stopping by. The ladies was in the building. All my moderators, thank y'all so much. Thank you to everyone that sent me a cash app or left a super sticker. I want to thank you. Appreciate it. All right, now we're gonna get ready to I'm gonna get ready to get out of here. I'm gonna play this little clip and we're gonna be out of here. All right, guys. Thank you so much. You guys have a wonderful night.
It's been a long, long time, honey, but I know, yeah. Story. Everybody ain't your friend, everybody ain't your partner. I say I got you. Well, just hold it down and keep it solid. And when you're not around, I protect your name, I won't talk about you. Everybody ain't your friend. Fake love, I don't need it, you can keep it as a fact. Yeah. Fake